Government Reform will reconvene. This is a continuation of our September 13th hearing on the examining the preservation of State Department federal records. We are scheduled to have Mr. Pagliano attend this hearing. Due to his absence and his violation of a duly issued subpoena by the Committee on Oversight and Government Reform, we intend to adjourn this hearing and immediately convene a business meeting to reconsider a resolution and report holding Mr. Pagliano in contempt of Congress. Does Mr. Cummings, do you have a statement, or can we go ahead and adjourn?
I have a brief statement.
Sure.
Well, let me just say this. This is certainly no surprise to anyone. Mr. Pagliano's attorney told us last week he wouldn't be here. They told us it would be an abuse to force him to appear for a second time before Congress just to assert his Fifth Amendment rights. And they sent us another letter last night saying exactly the same thing. Let me read from one portion of the letter so there's no question about what is going on here. And I quote, "We have corresponded extensively with you and the committee's attorneys over the past 2 weeks on this subject. The facts have not changed." Continuing the quote, "You and the committee have been told from the beginning that Mr. Pagliano will continue to assert his Fifth Amendment rights and will decline to answer any questions put to him by your committee," end of quote. The letter explains that he already asserted his Fifth Amendment rights before the Benghazi Select Committee, and he should not be forced to do so a second time. The letter continues, and I quote, "A subpoena issued by a congressional committee is required by law to serve a valid legislative purpose, and there is none here. You demand, under the present circumstances, that Mr. Pagliano again assert his constitutional rights in front of video cameras 6 weeks before the presidential election, betrays a naked political agenda and furthers no valid legislative aim," end of quote. I ask unanimous consent that this full letter from Mr. Pagliano's attorney sent last night to the committee be entered into the official record. I have nothing else on that, Mr. Chairman.
Without objection, so ordered. The hearing is adjourned. Committee on Oversight and Government Reform will now come to order. Pursuant to Committee Rule 5B and House Rule 11-2H4, the committee announces that it may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote of the yeas and nays are ordered. And without objection, the Chair is authorized to declare a recess at any time. This is a full committee business meeting to consider the resolution and report recommending to the House of Representatives to find Bryan Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. Our first and only item for consideration today is a resolution and report recommending that the House of Representatives find Bryan Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform. The clerk will designate the report.
Resolution recommending that the House of Representatives find Bryan Pagliano in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on Oversight and Government Reform.
I intend to offer an amendment in the nature of a substitute to the report, and without objection, we will call up the amendment in the nature of a substitute, and then I will recognize myself to give one statement on both the ANS and the underlying report. The clerk will designate the amendment.
Amendment in the nature of a substitute offered by Mr. Chaffetz of Utah to the resolution recommending that the House of Representatives find Bryan Pagliano in contempt of Congress.
Without objection, the amendment is considered as read, and I now recognize myself for 5 minutes and a statement to report on the report and the ANS. Today, the committee will consider a resolution and report recommending Bryan Pagliano be held in contempt of the House of Representatives. Subpoenas are not optional. Mr. Pagliano is a crucial fact witness in this committee's investigation of former Secretary of State Hillary Clinton's use of a private email server to conduct government business. The release of these federal records is of deep concern to the committee, and we have the jurisdiction over federal records. We have jurisdiction over National Archives. We have jurisdiction in several places. Over the course of the investigation, we learned some of the information about Mr. Pagliano's involvement in Secretary Clinton's use of the private server. Mr. Pagliano originally worked for Secretary Clinton in her 2008 presidential campaign as an IT specialist. As he was closing out her campaign's computer equipment, he received a call from Justin Cooper, who testified before this committee last week. It was Mr. Cooper who requested Mr. Pagliano build a server for Ms. Clinton in early 2009 as she started her new job as Secretary of State. Several months later, in March of 2009, the two men met in the basement of Clinton's Chappaqua residence to install a new server Mr. Pagliano built. Mr. Pagliano continued to monitor and maintain the server while Secretary Clinton was at the State Department. After he set up the server, Mr. Pagliano joined Secretary Clinton at the State Department as a Schedule C appointee in the Bureau of Information and Resource Management. By law, Schedule C appointees are required to report to a presidentially appointed position, but there were no presidential appointees in the Bureau of Information and Resource Management, making Mr. Pagliano's employment arrangement unusual at best. Other employees in his Bureau later questioned his ability to support a private client's email server, given his capacity as a full-time government employee. Mr. Pagliano left the State Department in February of 2013, the same month as Secretary Clinton. Even though he worked at the State Department for almost 4 years, the agency has been only able to find a handful of emails. We have questions about this. Mr. Pagliano's emails are Federal records, just like Secretary Clinton's emails, and subject to production in response to a Freedom of Information Act request. The committee has jurisdiction of both the Federal Records Act and FOIA. We also have a long record of oversight, investigative, and legislative work in this area. The committee subpoenaed Mr. Pagliano to appear at a hearing on September 13, 2016. He did not show up to that hearing. I explained Mr. Pagliano was uniquely qualified to provide testimony to help the committee better understand Secretary Clinton's use of a private email server. This is undisputable. I also made clear the committee would consider all options regarding Mr. Pagliano's failure to appear, including consideration of recommending he be held in contempt. The committee then heard several hours of testimony from Mr. Cooper, who was also involved in setting up Secretary Clinton's email server. Mr. Cooper, to his credit, explained a lot. We did appreciate his participation in answering all the questions that this committee asked. Throughout his testimony, Mr. Cooper routinely referred to Mr. Pagliano as the individual more appropriate to answer questions who knew more about the server. It was clear from Mr. Cooper's testimony, his words, not ours, that we needed to hear from Mr. Pagliano. Mr. Pagliano's attorney asserts because his client took the Fifth before the Select Committee on Benghazi, he shouldn't be required to provide testimony to this committee. That is not a good faith argument. It makes no sense for a number of reasons. First and foremost, the Select Committee's jurisdiction is limited. It only relates to September 11, 2012 terrorist attack in Benghazi. In contrast, this committee's jurisdiction is broad and includes both legislative and oversight of the Federal Records Act and the Freedom of Information Act. Questions about these two topics alone are well outside the purview of the Select Committee's investigation. Secretary Clinton's emails and Mr. Pagliano's were subject to both of these laws. Mr. Pagliano could explain what he knew or what he was told about these laws. He could tell us whether or not they were considered by him or others in setting up Secretary Clinton's private email server. Mr. Pagliano's testimony could provide important information informing legislative reforms that this committee may want to consider, ensuring that this disaster never happens again. This includes reforms based on how he was able to prevent the State Department from locating most of his emails. Another key difference in last month, this committee had the benefit of reviewing the testimony Mr. Pagliano did provide during his interview with the FBI. The Select Committee never did see that 302. Nor was the Select Committee aware of the thousands of classified emails that traveled over Secretary Clinton's server when they spoke with Mr. Pagliano. This committee's questions are broader and more informed than any questions posed by the Select Committee, making a comparison unnecessary. Further, answering a number of these questions could never subject Mr. Pagliano to criminal liability. The Department of Justice has confirmed Mr. Pagliano was granted immunity before he spoke to the FBI. Director Comey confirmed that he was recommending no charges be brought against anyone involved in the matter. Attorney General Lynch accepted the recommendation and closed the case. Under those circumstances, Mr. Pagliano has no fear of criminal liability, preventing him from answering questions before this committee. The committee recessed its September 13th hearing with Mr. Cooper to give Mr. Pagliano another opportunity to show up and testify. to clear up any ambiguity created by Mr. Pagliano's 6 lawyers about whether they would confirm service of the prior subpoenas, which they refused to do, we had the U.S. Marshals personally serve him. We scheduled the continuation of the earlier hearing for this morning, but once again, he failed to show. This committee cannot operate, it cannot perform its duty, nor can any committee of Congress if subpoenas are ignored. So we are left with no choice but to consider this resolution and report recommending the House hold Mr. Pagliano in contempt of Congress. Now, recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. Yesterday, our committee held a very important hearing on a very critical issue that matters to millions of the American people, the skyrocketing prices of prescription drugs. Members on both sides of the aisle joined together to examine these abuses in a truly bipartisan way. That is exactly the kind of investigation our committee should be conducting, and that is the kind of investigation that the American people would want us to conduct. But today's spectacle is just the opposite. This is nothing but a blatantly partisan Republican attack on the Democratic candidate for President of the United States of America. It undermines the integrity of our committee, and it makes our constituents disgusted with Congress instead of proud of our work. Today is our 5th day of, quote, emergency, end of quote, hearings on Hillary Clinton's emails in the past 3 weeks. 5th day of emergency hearings on Hillary Clinton's emails in the past 3 weeks. In that period, the Chairman has issued an astonishing 12 subpoenas. If you don't count weekends, that's more than 1 a day. It's also more than 1/3 of the total number of subpoenas he issued in all of 2016. Got an emergency here. And he issued every single one unilaterally with no debate. I asked the question, are Hillary Clinton's emails really worth 1/3 of the committee's attention? Of course not. And what exactly is the emergency? As far as I can tell, the only emergency is the election approaching in a few weeks. I suppose the Republicans could argue that since Hillary Clinton's running for president, the American people should know everything they can before entering the voting booth. If so, I ask the simple question, then where is our investigation of Donald Trump? His potentially fraudulent business practices, his campaign's potential connections to Russian hackers. What about that emergency? His charitable foundation's illegal campaign donations, pay-to-play schemes, and payments to settle corporate debts. The answer is obvious. The Republican frenzy is focused exclusively and obsessively on Secretary Clinton, and that is for political reasons. I do believe that this is an abuse of authority and taxpayer dollars to inappropriately affect the presidential election. There's one key fact that everyone needs to understand about today's vote. Mr. Pagliano has already asserted his Fifth Amendment right before this very Congress on this very topic. In fact, he did it in person, right in front of me and Chairman Gowdy on the Benghazi Select Committee. This critical fact is not mentioned anywhere in this contempt resolution. Not mentioned. You can search all you want, but you will not find it. Why is that fact so crucial? because it demonstrates that there is no legitimate legislative purpose in forcing Mr. Pagliano to assert his Fifth Amendment rights before Congress a second time. And there is certainly no legitimate purpose in forcing him to do so in public. To do so could open the floodgates for every Republican-led committee on Capitol Hill. Committee members may not know this, but last Friday, the chairman sent U.S. Marshals, yes, U.S. Marshals, into Mr. Pagliano's workplace to personally serve a second subpoena for his appearance before the committee. The committee could have sent a staffer in a coat and tie, but they sent federal marshals with guns. This served no purpose but to harass and intimidate Mr. Pagliano. The chairman ordered this action in secret, without even notifying the Democratic committee members of his plan. Got an emergency going on here. Secret. No consultation? Secret. No debate? Secret. No vote? Secret. Emergency. These actions are the definition of abuse. They are harassment. And I believe that they are unethical. I've said it before and I've said it again. And I echo the passion of Mr. Lynch, who has spoken on this subject extensively. The committee's actions in trying to force Mr. Pagliano to come back to Congress and invoke his Fifth Amendment rights yet again raise serious legal, ethical, and constitutional concerns. Members should not be placed in a position of voting for a resolution that could subject them or their staffs to potential disciplinary action. The American Bar Association, the D.C. Bar, and the Maryland Bar, which I have been a member of since 1976, all have ethics rules that prohibit attorneys from taking actions to embarrass, harass, or burden private citizens. It is professional misconduct. The D.C. Bar's Legal Ethics Committee warns that no attorney should compel any witness to appear in a congressional hearing when, and I quote, "it is known in advance that no information will be obtained and the sole effect of the summons will be to pillory the witness," end of quote. That is exactly what we have here. Now, Republicans may try to argue that Mr. Pagliano received immunity from the Justice Department, but that immunity agreement was limited, and we all had the opportunity to read it just this morning to confirm that. That is why a federal court has already ruled that Mr. Pagliano can continue to assert his constitutional privileges in separate proceedings, which he has done. As I close, what exposes the committee's abuses for what they really are is this. If the chairman really wanted to just obtain Mr. Pagliano's Fifth Amendment assertion for the record, he could have easily held a closed deposition, just as Chairman Gowdy did on the Benghazi Committee. But that is obviously not the goal here, ladies and gentlemen. Republicans want a photo op. They want a ready-made campaign commercial. No matter what anyone says, that is not a legitimate legislative purpose, and as I've said before, I deem it and believe it to be unethical. Although I strongly support the committee's authority and prerogatives of the House of Representatives, I simply cannot vote for a resolution that is potentially so unethical that it could subject members of this committee or our staff to disciplinary action. For all of these reasons, I urge all the members to vote no on this resolution, and I yield back.
Gentleman yields back. I'd ask unanimous consent to enter into the record all the correspondence we've had with Mr. Pagliano's attorneys. Without objection, so ordered. Does any other member wish to speak on the amendment in the nature of the substitute? Are there any?
Yeah, I do.
Oh,
I would
we'll
refer to
recognize
my
Mr.
Republican
Micah.
colleagues. I think they're next.
We'll recognize Mr. Micah of Florida.
Okay, thank you.
Well, thank you, Mr. Chairman. And this is a difficult situation when you have to hold someone in contempt or vote. But again, I have to refer to my years on the panel and being the senior member. What we do here in this committee, ladies and gentlemen, my colleagues, one of the most important things that anyone has to do in our government. We all represent hundreds of thousands of incredible people who today are working, struggling to make a living, pay their taxes, raise their families, and retire someday. And they send us here to make certain that the Constitution laws of the land are upheld. And we have one of the most important responsibilities in this committee to see that just that is done. Our responsibility and authority under the Constitution gives us the right to demand the appearance of any individual, particularly those who have been involved in government activity, and legitimately ask questions of them. This gentleman was requested in a proper request to appear before us. We had others who came at that same hearing and they had the same opportunity. They exercised their Fifth Amendment right. They took the Fifth Amendment. This gentleman defied and was in contempt of this committee. He was in contempt. We can't make this government work. We cannot function if people will not adhere to the Constitution, the rules, and the basic ability of the Congress to talk to these people. He could have come here, and immunity, or whether it's limited or not, doesn't make any difference. He would not be denied his Fifth Amendment right. He could have expressed that here. But you cannot have as an option. You will destroy this committee. You will destroy the congressional oversight process. And whether it's a Republican or Democrat, now listen to this. It doesn't matter whether it's Chairman Chaffetz or if it was Chairman Cummings. We cannot have people come here and deny the right under the Constitution for us to question them. They may not want to answer, and they have that right under the Constitution, just like we have the right to question them. So again, this is very fundamental to the process. He acted in contempt. He thwarted the Constitution and laws and the procedures that will and if you continue that, you destroy the whole basis of our government. That's the difference between our government and other governments. And it's really the principal responsibility of this committee. So I tell you, this isn't, again, a partisan issue. It's not a political issue. This is an issue that goes to the very core of the integrity of our democratic and constitutional process. Mr. Chairman, I yield back the balance of my time.
Thank the gentleman. Does any other member wish to speak? We'll recognize the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. It is my opinion, at least from the course of these investigations, that Mr. Pagliano has indeed previously complied with the subpoena for the same information that the committee seeks today. And he has been given limited use immunity, only limited use immunity in the previous interviews, which would, again, expose him to possible prosecution if he were to, I think it's reasonably predictable that he would be subject to criminal prosecution because of the referral by this committee on this matter. In essence, what's going on here is this is really what we're engaging in is a review of the decision by Director Comey not to prosecute. That's what we're doing here. That's why the prosecutorial notes were requested by this committee and surrendered. That's why all of this is ongoing, because this committee wishes to go beyond the legislative function we have and to have a de novo review of what the Attorney General has dismissed and closed, and what the Director of the FBI has refused to prosecute. I think that especially this is a violation of the separation of powers clause in the Constitution. I think what we're doing here today is something that is denied even to the judiciary. When a prosecutor looks at the facts, and this was an extensive interview process, review process, investigation process, when they decide that there are not sufficient facts to basically review the decision of the FBI not to prosecute in this matter. And this particular hearing to hold Mr. Pagliano in contempt, it really boils down to this, is that the chairman is saying that his rule is that the witness has to come before the committee and be subjected to what the witnesses were subjected to last week, which was total embarrassment. We had quotes of emails that were read and other evidence, and forcing them to repeatedly declare their Fifth Amendment rights, being publicly embarrassed on TV. That's the chairman's rule, but that is not the law. We know because in previous hearings, Mr. Gowdy, and I give him credit, in compliance with the law, brought that witness in a closed hearing in executive session, and that witness exercised his Fifth Amendment rights. And that was the decent and fair and legal thing to do. That's not what we're doing here. We're continuing to try to embarrass this particular witness as Mr. Gambetta and other witnesses were embarrassed, Mr. Thornton, last week. And that is not necessary. And I think it's beneath the dignity of this committee, and as well, I think, violative of the constitutional rights of that witness. That's what this boils down to. And I think this contempt proceeding will have short shrift in the district court. I don't think it's going anywhere, and I take comfort in that fact, because we are so far afield from the Constitution again in this committee. Not only the Fifth Amendment, but also now the separation of powers, where we try to take up anew this this matter that's been settled by the FBI Director and the Attorney General.
I thank the gentleman. Gentleman's time.
Gentleman, yields back.
To recognize the gentleman from South Carolina, Mr. Gowdy, 5 minutes.
Thank you, Mr. Chairman. I suspect most members of this committee know how they're going to vote. They probably knew earlier this morning how they're going to vote, so I don't think any of this is going to change any minds. But I do want to talk for a second to the folks who may be following this back home, just trying to figure out what these lawyers are arguing about. Mr. Chairman, there are two separate issues at play. Number one is whether or not you have to come when you have been issued a summons or a subpoena. There are people sitting in jury rooms right now all across this country because they received a summons. Even though they're not going to be called for jury service, they may be excused, they may frankly be disqualified, but you still have to come. There are subpoenas being issued all across this country to firefighters and EMS and police officers and doctors and everyone else who may have witnessed anything from a crime to a traffic accident, they may not get called as a witness, but they have to come. So issue number one is whether or not you have to come when you are issued legal process. And the answer is yes. The witness himself or herself does not get to pick and choose which legal process you're going to follow and which one you're not, or nobody would go to jury service. So issue number one is, do you have to come? Issue number two is whether or not you have to talk. And unless your name is Jack Bauer, you cannot force anyone to talk. Now, we can have a robust debate about whether or not this witness has been immunized. I read the immunity agreement. And what I find interesting is the doublespeak that I hear from some of my colleagues. You cannot, in one sentence, say DOJ has refused to prosecute, that this is a nothing case, and then the next sentence say you're worried that DOJ is going to prosecute. Congress cannot prosecute anyone for anything. Nothing. The only entity in this country that can level criminal charges is the executive branch. And they have already said they're not going to do so. So where is his criminal exposure? Where is it? Unless they're going to say, Mr. Chairman, that we are worried that he is going to make a false statement before Congress. Now, that would be interesting if that's the argument. We are worried that this witness who cooperated with the FBI may tell Congress something different. Well, guess what? The agreement he has with the Department of Justice requires him to be truthful. So you would want people to say the same thing to Congress that you say to the FBI. This is what I find most interesting of all. The Department of Justice has already said they're not going to prosecute anybody for anything. This matter is closed. Nobody's going to be prosecuted. But I'll bet you that agreement allows for this witness to cooperate with other entities of government. In fact, in the old days, it required that witness to cooperate with other entities of government. And I'll tell you why, Mr. Chairman. I have sat while some of the very members who are sitting in this room right now provided oversight over the FBI, over national security letters. They didn't give one whit second thought about second-guessing the FBI and the issuing of national security letters. I mean, who else would provide oversight over the FBI if not for Congress? And I listened to some of the very same members on this committee provide oversight over the Department of Justice, over the prosecution of Ted Stevens. So they have no problem providing oversight over the Department of Justice when they don't like the outcome. But when they do like the outcome, oh, no, we cannot second guess. That is the one entity in this republic that can never be second guessed is the FBI. I find that fascinating, particularly coming from as many criminal defense attorneys as we have on the other side, who made a dadgum living questioning the FBI. I mean, that's how they made their living, is second guessing the FBI. But no, once you take the oath of office for Congress, whatever they do, you don't want to prosecute the big banks, FBI, we're fine with that. You don't want to do anything about the people who committed fraud during the housing crisis, we're fine with that. God forbid we ask the FBI anything. All I want to know, Mr. Chairman, is did you give immunity to the person who destroyed federal records after a subpoena was in place? That's a fair question, and I would think every member of Congress would want to know the answer.
Gentleman's time has expired. Does any other member wish to speak? We'll now recognize the gentleman from Virginia, Mr. Contempt.
Thank you, Mr. Chairman. And my friend from South Carolina wanted to help clarify for the folks back home what this is all about. And I don't know if he did that, but certainly the rising tenor of his voice suggests outrage about something that has gone awry. So let me take my crack at talking to the folks back home. What's gone awry here is the trampling of your rights and our fellow Americans. Election not going well, presidential level. Maybe we can take a piece out of Hillary Clinton, and Pagliano might be the key to doing that, or at least a key. And so we're going to send marshals, U.S. marshals, to someone's office to degrade and humiliate him, and overreach if there ever was one, and we're going to do it without any consultation with this half of the committee, which kind of tells you they're up to something they don't quite want us to know about. My friend from South Carolina says there's a double standard. I certainly supported the critique of the prosecutors that they overreached with Ted Stevens. It was wrong. In my own home state of Virginia, I don't applaud the actions of our former Republican governor, but I supported the Supreme Court ruling that it was prosecutorial overreach and that there was way too much ambiguity in the standard of what constituted a quid pro quo. I was sensitive to their rights, and my colleagues here, many of them, shared that sensitivity and that concern. But we also share a concern about a broader principle here than a short-term political cheap shot in the hopes it might work, and the Fifth Amendment rights of a U.S. citizen be damned. That's not right. And after all of the Sturm und Drang is over in this election cycle, the sad legacy of the expediency of dispensing with a constitutional right of every American to protect himself or herself against legal jeopardy, to have a set-out process that protects them from testifying if they choose not to, whether we like it or not. And it isn't, sadly, the first time we've trampled on those rights. We self-declared somebody, in fact, had voluntarily given up her Fifth Amendment rights, even though she protested that was not true, even though her attorneys insisted that was not true, and even though there's plenty of case law during the McCarthy era, ironically, that clearly suggests that's not the standard. But that didn't stop us. So today we're going to vote on a party line vote, and we're going to further sully and degrade the reputation of Congress and of this committee. And it ought to make every American tremble just a little bit. Because if we can do this to Mr. Pagliano, we can do it to you. And oh, by the way, while we're at it, what other rights in the Constitution? Because we know not the Second Amendment, because that's sacred. That's uber alles. That's not conditional in any way, shape, or form. But the First Amendment, not so much. Fifth Amendment, apparently not at all. And we'll get to the rest if it's convenient, if it's expedient, if it politically serves our interests. When I took an oath for this job, it wasn't to insist that Mr. Pagliano compromise his rights at that table and be humiliated. It was to protect the constitutional rights of every American to the best of my ability. And we're about to compromise those rights in this vote. And that's wrong, and that's a legacy none of us should be proud of. I yield back.
Thank the gentleman. Does any other member wish to speak on the ENS? Ms. Maloney is, but we'll come to Ms. Maloney first. I think we actually have to go to Ms. Plaskett first for 5 minutes.
Thank you, Mr. Chairman.
Okay, no problem.
My colleague from South Carolina knows that not everybody on this side of the aisle was a criminal defense attorney. Some of us were actually prosecutors and could never see themselves as a criminal defense attorney. So I take going within the scope of the law extremely seriously. And I'm very concerned about this being an unethical act on the part of this committee. Now, my colleagues questioned that this is not about politics and this is not partisan, so I'm wondering what it is about. And I think it's about an abuse of power and a waste of time. And it's a waste of this committee's time, and it's destroying this committee. It's destroying the reputation of this committee because it's very clear what Mr. Pagliano would do if he came here. I guess many of my colleagues believe that they can break the man and take away him asserting his Fifth Amendment right, when his attorneys have told us in writing that should he be brought here, he will assert his Fifth Amendment right to every question. So what's the point? What's the point of bringing him here and having him in contempt in front of a camera, except for the camera? Because it's something we could do in closed doors, under deposition, and it would be on the record. His attorneys have been very clear in writing that if he came before this committee, he would continue to assert his right as to all questions, and they offered to bring him to personally assert his rights in a closed session. But that's not good enough for this committee. That doesn't serve the purpose of what this committee is wants. I thought my colleagues were interested in coming to the truth and to finding out information that we hadn't already found out, that that's the purpose of the Oversight and Government Reform Committee. But it seems really that the name of this committee possibly should be changed to the Abuse Committee, the Abuse of Power Committee, the committee that likes to make sound bites, the committee that likes to be on CNN and MSNBC and have political fodder for whatever it is they need it for. That's a problem. And it's also a problem because we're not protecting the attorneys that are on this committee. Because it's very clear under legal ethics rules set forth by the American Bar Association, as well as the District of Columbia Bar, that if we move forward on this, you're exposing the attorneys who practice or have decided that they want to keep their bar standing, or the staff attorneys. I'd like to ask the chair, are we going to protect the attorneys that are here if contempt should be brought against them in a place where they can actually have criminal charges, that being a court of law? Is our attempt to be in front of a camera so important that the staff that work for us should be put out on a limb for us to be able to meet our needs, our expediency before November 8th? Or, as I understand from some of the assertions that have been made, maybe even after January 20th, if it doesn't go the way that they want it to go. So I pose that question to this committee as to how far we're willing to go. Are we going to expose the attorneys that are here and practicing and trying to uphold the law because we want to skirt the edges a little bit for the political expediency that we need to move forward in this? And I yield back the balance of my time. Yes, Mr.
Let me say this. First of all, I want to thank you for raising the issue with regard to the ethical rules of the bar. I said a little bit earlier that I've been a member of the Maryland Bar since 1976, and I worked hard to get that license. As a matter of fact, even though I'm not practicing now, I still pay my bar deal dues because I don't want anything to happen to that license. I worked hard for that license, and I've sworn to uphold the ethical rules of my profession, just as I know you have, not just the letter of the law, but the spirit of the law. And Maryland, like D.C., has a legal ethical rule that says, and I quote, and this is the Maryland rule, an attorney shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, end of quote. And so I just do not see how the actions of this committee regarding Mr. Pagliano would do anything other than that, and that's why I'm voting against this. And I thank the gentlelady for yielding and bringing up the point.
I thank the lady. Gentlewoman's time has expired. Gentleman from Texas, Mr. Farenthold, is recognized.
Thank you very much, and I'll be brief, Mr. Chairman. I'm not concerned about voting for this. I'm a licensed attorney, and I'm confident that any legislative action I take will be protected under the Speech and Debate Clause of the United States Constitution that says I shall not be questioned in any other forum for any activity I take as a legislator. I yield back.
Gentleman yields back. Does any other member wish to speak on the NS? Gentlewoman from New York, Ms. Maloney.
Thank you, Mr. Chairman. And Mr. Chairman, you have repeatedly claimed on television and other places that this is, and to quote your words, one of the biggest security breaches in the history of the State Department, end quote. Now, this claim is completely false, outlandish, and frankly, really unsubstantiated in any way, shape, or form. The FBI director has been on record and has said already and concluded, and I am quoting from the FBI director, "We did not find evidence confirming that Clinton's email server system were compromised by cyber means," end quote. Now, the FBI is an independent agency, apolitical, nonpartisan, whose purpose is to find the truth, protect the American people, and protect our system of government. And they found that this was totally unfounded and outlandish and untrue. So what are we doing? The only person that is being hurt by this is Hillary Rodham Clinton. The FBI has already said there's no case there. There was no harm there. But in contrast, the official State Department system was hacked in 2015 by a reported Russian hacker, and it apparently was a terrible cyber intrusion against a federal agency and against our country. So I would like to put this in perspective about what we're really talking about. And some members of this committee may not remember that in the 1990s, this is exactly what the Republican leadership did under former Chairman Dan Burton, who was chairman of this committee. They falsely accused, undisputedly, historically, they falsely accused the Clinton White House of intentionally destroying emails to hide them. And they launched hearings, massive investigations, and their claims turned out to be completely false, completely unsubstantiated, just like these claims that they're putting forward now are unsubstantiated. And then, back then, just like today, they wildly exaggerated their claims. And I want to read from the actual report that this committee put out under former Republican Chairman Dan Burton in October of 2000, and where they actually claimed that the fake scandal was bigger than Watergate. And may I quote from their report, "The email matter can fairly be called the most significant obstruction of congressional investigation in United States history. While the White House obstruction in Watergate related only to the Watergate break-in, the potential obstruction of justice by the Clinton White House reaches much further." Well, this was preposterous. And I read last night a report, and I asked unanimous consent to place it in the record by the Democratic minority at that time, called "Unsubstantiated Allegations of Wrongdoing Involving the Clinton Administration." So I feel, may we put this in the record?
Without objection, so ordered.
Thank you. And I urge everyone to read it. And what we have today is another deja vu, a repeat of the same false allegations. And I would venture to say that they are political, totally politically motivated. Our independent FBI said there isn't a problem here. They are trying to create one with false allegations. And here we are again, and the same Republican hysteria is now being thrown at another Clinton, the same unsubstantiated allegations, the same completely exaggerated false claims. And I urge the listening public to read the report of the FBI on the current emails and to read the report on the prior hysterical hearings that proved to have no basis to truth and reality. My time has expired.
Gentlewoman's time has expired. I would like everybody to read the FBI report. Unfortunately, it has not been released in its totality. We'll now recognize the gentleman from North Carolina, Mr. Meadows.
Mr. Chairman, I appreciate your recognition. I would just like to ask the gentlewoman from New York to remind her of the rules that we have.
Members are advised to not address other members. They can address the chair, but they cannot address others.
Well, Mr. Chairman, I would make a point of order. The debate here is getting to bring in personalities. We have rules in this committee where attacking members, either their motives or anything else, is not to be done. And so I would kindly ask the chair to remind members that if they're going to make personal attacks, that they need to keep those in a generic and non-specific form. I yield back.
Before the gentleman yields back.
Point of personal privilege, since my name was mentioned. Mr. Chairman, may I clarify?
No, not yet.
I was talking about claims, not a member.
I said no.
Claims.
No, okay. What the gentleman has yielded to me. Members are advised, and I'll read from what the parliamentarian gave me. Members are advised they must observe the House's standards of decorum and debate and conduct. They must speak and act respectfully, and they may not use disorderly words or unparliamentary language, such as words impugning the motives of other colleagues, end quote. So my point here is you can be disgusted by it. You can be frustrated by it. There is a seminal question. I don't think it's a partisan question. When there is a duly issued subpoena, that person must appear. It is not an optional exercise. It's not, hey, I want to dial it in by sending a letter from my attorney. That, no matter which side of the aisle you're on, if you believe in the rule of law, if you believe in the morality of our Constitution, it requires people to obey that law. Now, non-attendance is not an option, and I feel very strongly about that. Mr. Cummings talked about in his statement about secret this and secret that. I believe it should be as open and transparent. I don't think it should be done behind closed doors. I do think it should be open and transparent. That's the way, in large part, the judicial branch operates, and I think it's the way this committee should operate. To the maximum extent possible, I'd like it to be as open and transparent as possible. I think we issued we issued a subpoena in the right way, and it is not an optional exercise. And that is the question today, because twice, I mean, I was very generous, twice we gave him an opportunity to show up. And I wish we weren't here today. We shouldn't have to be here today. But that was the choice that was made, and we're left with but no choice to hold him in contempt. He violated the subpoena. So I yield back to the gentleman from North Carolina.
Gentleman, yield.
Certainly.
I just would hope that Ms. Maloney her name came up, and I think she was just trying to take a minute to explain what she was trying to do, and I would just ask that she be allowed to do that.
Well,
I admonished the member.
reclaiming my time.
Remember that he was not supposed to.
Well, reclaiming my time, I didn't mention anybody's name. I mentioned the gentlewoman from New York, and specifically as it relates, the ranking member will know full well that this is something that is very personal to me, because I came to his defense when someone on my side attacked him. And so it is important that we have debate. It is important that we do that without personalities involved. And we must rise to the occasion to have differences without making personal attacks. And I'll yield back the balance of my time.
Gentleman yields back. Does any other member
Point of personal privilege?
No. I want to give members each an opportunity to, if they have if they'd like to speak on the A&S. Does any other member wish to speak on the A&S? Oh, sorry, Mr. DeSantis, now recognized for 5 minutes.
Yeah, Mr. Chairman, when I hear some of these things, I sat and listened to Director Comey. I've read the reports. He did say that the FBI did not find evidence that Secretary Clinton's email system was hacked by foreign agents. The implication that was just made by the gentlelady from New York is because that did not, in fact, happen. That is not what Comey said. What he said was, we would not have been able to determine if they had done it because they're sophisticated. And if you look at somebody like former director, deputy director of the CIA, Mike Morrell, who's actually supporting Secretary Clinton for president, he said basically any good intelligence service would have anything on any unclassified system, but particularly something that like Secretary Clinton's emails. And so I think the issue that this subpoena is driving at is you had a lot of classified information on unclassified server. You have people like Pagliano, Gambetta, who were involved in that. And we have a fact pattern in which those emails were deleted after not only being revealed publicly, not only after being subpoenaed by Congress, but after Gambetta had a conversation with people affiliated with Secretary Clinton. And then, of course, we now are, these Reddit transcripts have been found by people online that strongly suggest somebody with a similar profile to Gambetta talking about, hey, I want to figure out how to strip a VIP's email address from a bunch of emails. Once that became public, it was deleted. So there's just a lot of questions about how the IT side of this investigation was handled, whether the FBI pursued a case involving potential obstruction of documents, and people like Pagliano and Gambetta are just central to that. So I think it's really an appropriate use of oversight authority, because I think people who know, who've been involved in the federal system, a lot of times if the FBI can't get you on a substantive offense, they go after the process crimes, lying to them, obstructing justice, destroying evidence. And there didn't seem to be, from the reports we've read, that concerted of an effort to do that in this case. And so I'm supportive of what the chairman is doing, and I yield back.
Thank the gentleman. Are there any other members wish to speak on the ANS? Are there any? Recognize the gentleman from Alabama, Mr. Palm.
Thank you, Mr. Chairman. I've been reluctant to speak on this, but I feel compelled to, because I think this is bigger than the email issue. It's bigger than the politics that our colleagues keep bringing up. It's about the rule of law. It's about constitutional separation of powers. And I'm not the only one that feels that way. Jonathan Turley and Lawrence Tribe, who are widely recognized as preeminent liberal law professors, have warned that the Constitution is in grave danger. I think it's essential that we, as a committee, exercise the authority and responsibility invested in us by the Constitution to protect the nation from abuse of power by the executive branch, abuse of power by the Justice Department. I mean, clearly, it's against the law to destroy evidence. Evidence was destroyed. It's clearly against the law to alter documents, and documents were altered. It's clearly against the law for people who are not authorized to handle classified information to be given classified information. And it's our responsibility to protect the Constitution and protect the nation against people who violate the law. It shouldn't matter what party's in power. It shouldn't matter who did it. That's our responsibility. It shouldn't matter what point we are in an election cycle. That's our responsibility. And when you have law professors, such as Lawrence Tribe and particularly Jonathan Turley, who testified in a Senate Judiciary hearing, that we're watching a fundamental change in our constitutional system, and it's changing in the way that the framers warned us to avoid. So I think this is bigger than the politics. It's bigger than the issue. It's about preserving the separation of powers, and this committee upholding its constitutional oath of office to do its duty. I yield back.
Thank the gentleman. Are there any amendments to the amendment in the nature of the substitute? Any other member wish to speak? Question is now on the amendment in the nature of the substitute. In favor signify by saying aye. Aye. Those opposed, no.
No.
The opinion of the chair, the ayes have it, and the amendment is agreed to. It's just the amendment in the nature and the, you want to do it on the ANS? Yeah. And the overall, because that was just the amendment. Okay. The question is now on adoption and favorably reporting the contempt report as amended and transmitting the report as adopted for filing as a privileged report to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
The opinion of the chair, the ayes have it. The roll call has been requested. Clerk will call the roll.
Mr. Chaffetz?
Aye.
Mr. Chaffetz votes aye. Mr. Mica? Mr. Mica votes aye. Mr. Turner? Mr. Duncan? Mr. Duncan votes aye. Mr. Jordan? Mr. Jordan votes yes. Mr. Wahlberg? Mr. Amash? Mr. Amash votes yes. Mr. Gosar? Mr. Desjardins? Mr. Desjardins votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Farenthold? Yes. Mr. Farenthold votes yes. Mrs. Lummis? Mr. Massey? Yes. Mr. Massey votes yes. Mr. Meadows? Yes. Mr. Meadows votes yes. Mr. DeSantis? Mr. DeSantis votes yes. Mr. Mulvaney? Mr. Buck? Mr. Walker? Mr. Walker votes yes. Mr. Blum? Mr. Blum votes yes. Mr. Heiss? Mr. Heiss votes yes. Mr. Russell? Mr. Carter? Mr. Grothman? Mr. Grothman votes yes. Mr. Hurd? Mr. Hurd votes yes. Mr. Palmer? Mr. Palmer votes yes. Mr. Cummings? Mr. Cummings votes no. Ms. Maloney? Ms. Maloney votes no. Ms. Norton? Mr. Clay? Mr. Clay votes no. Mr. Lynch? Mr. Lynch votes no. Mr. Cooper? Mr. Connolly?
Never, no how, no way, no.
Mr. Connolly votes no. Ms. Duckworth? Ms. Duckworth votes no. Ms. Kelly? Ms. Kelly votes no. Ms. Lawrence? Ms. Lawrence votes no. Mr. Liu? Ms. Watson-Coleman? Ms. Watson-Coleman votes no. Ms. Plaskett? Ms. Plaskett votes no. Mr. Desaulniers? Mr. Desaulniers votes no. Mr. Boyle? Mr. Boyle votes no. Mr. Welch? Mr. Welch votes no. Ms. Lujan Grisham? Ms. Lujan Grisham votes no.
How is the member from the District of Columbia recorded?
Ms. Norton is not recorded. Ms. Norton votes no.
Does any other member, have all members been recorded? Oh.
Ms. Lummis is not recorded. Ms. Lummis votes yes.
Have all members had an opportunity to vote? Anybody else? How is the member from Michigan, Mr. Wahlberg, recorded?
Mr. Wahlberg is not recorded. He votes yes.
We good? Anybody else come? Anybody else? I think we're good. Clerk will report the tally.
On this vote, there are 19 yeas and 15 nays.
The ayes have it, and the report as amended is ordered favorably reported. Without objection, the motion to reconsider it is laid on the table. Without objection, pursuant to Clause 2L of House Rule 11, members will have 2 days to submit their views on the report considered today. I ask unanimous consent that the staff be allowed to make necessary technical and conforming changes to the report ordered reported today, subject to the approval of the minority. Hearing no objections, so ordered. If there's no further business without objection, the committee stands adjourned.